Janes v. Newport News School Board. Here are the participants of this case. Here's a little bit of background for this case. This case is about the resistance to parents seeking intervention services for their child, Brian and Juliana Janes, encountered when they went to their son Stefan's school district. Their son's school eventually developed an IEP, but without any of their input. In addition, the IEP was not put into action for several months. Stefan was diagnosed with autism at the age of 2, and it was then that his pediatric neurologist recommended to his parents that he get early intervention services from the Newport News School District. Here's a timeline that starts in 1992 and ends in July 2001. Here's a review of the IDEA. Remember that this law states that all students with disabilities have the right to a free, appropriate public education. Unfortunately, Stefan did not get this because of Newport News' actions, and which forced his parents to pull him out of their schools. Parents and guardians are supposed to be informed of their rights, as well as given opportunities to participate. Unfortunately, this did not happen either, especially when it should have. Newport News waited to inform Stefan's parents of their rights when they pulled him out of their school to place him in the LaVos program. An IEP was created as mandated, but was not put into action and had several holes in it. Here are some issues, violations, and complaints that surfaced quite frequently. The first one is related to how the IEP was implemented. The IEP that was developed had holes, was implemented late, and forced his parents to pull him out of school into a home intensive tutoring program, the ABA or LaVos program. The question of monetary reimbursement, this came up the most. Newport News tried to appeal this several times. The monetary reimbursement was for the cost of Stefan's ABA program tuition. Lack of parental involvement. The school did not involve Stefan's parents in the IEP development process, a violation of the IDEA, and also did not inform them of their rights either. Finally, the statute of limitations, in terms of how they were applied and whether or not they were applied correctly. Here are some resolutions, dispositions, and court decisions. There were 2 due process hearings. The first one, held in December 1998 and ended in June 1999, was with a local hearing officer. He ruled in favor of the Janeses and awarded them $117,979.78 for the cost of Stefan's ABA program tuition, and ruled that the school was negligent in handling his IEP. Newport News filed an appeal, and there's no due process, but with the state hearing officer. The state hearing officer ruled in the Janeses' favor, but reduced the monetary amount to half, and ruled that due to the statute of limitations, any claims filed before the filing date of 1997 were not valid and not taken into consideration. Continuing on, most of the courts and judges would come to the same conclusions found by the hearing officers in the due process hearings. However, when the court battle went to district court level, the school board was ordered to reimburse the Janeses for their son's educational expenses from 1995 to 2000. The U.S. District Court judge had come to the same conclusion and stated that Newport News' IEPs were full of deficiencies and that the district failed to ensure the parents, Brian and Juliana, were aware of their rights as required by law. Since the parents were not notified of their rights, their participation in the process was limited as a result. Resolutions, dispositions, and court decisions. The United States Court of Appeals at the Fourth Circuit. This time, the school board argued that their rights to challenge the monetary award were not waived. However, the court ruled otherwise. The case was heard in June 2001 and decided in July 2001, with a ruling in the Janes' favor. Yet again, the judges here also upheld the previous court rulings. This is where the Janes' legal battle with Newport News School Board would end. Even though the school board goes back to court 9 years later, it is not with them. is actually with the Commonwealth over a different issue that is related to how this case was handled. The court ruled that the school board waited too long to challenge the award. The court also ruled that the previous court ruling was not in error in awarding the monetary amount, that the school failed to notify parents of their rights, which prevented them from seeking recourse early on. Here are some constitutional questions. These three will pertain to the United States District Court for Eastern District of Virginia, the Norfolk Division. Are the petitioners time barred by the statute of limitations from bringing a cause of action against Newport News for violating IDEA? The judge found that both local and state hearing officers misapplied the statute of limitations. The judge agreed with the petitioner's assertion that the continuous inability of Newport News to provide Stefan with a free, appropriate public education is a claim that is not time barred. Any claims before the filing date of June 30, 1995 were time barred, however. Is the failure of Newport News to notify the petitioners of their right to a due process hearing, standing alone, sufficient to sustain a cause of action under the IDEA? It was decided that Newport News failed to notify the parents of their rights under IDEA. The judge explained that the promises of IDEA in regards to parental participation are empty ones if schools do not take time to inform these vital stakeholders of their rights. Therefore, because of the failure of Newport News to notify the Jameses of their rights, it is enough to sustain a cause of action under IDEA. Both parents stated in court that they did not even receive the parental rights in special education form until after they pulled their son out of school to place him into the LaVasse program. Are the petitioner's damages limited to the expenses incurred during a time period that is not barred by the statute of limitations, or do the damages consist of all educational expenses? The court decided that the petitioner's damages are entitled to the expenses that were incurred during the statute of limitations period and can be awarded for the damages through the present, from June 30, 1995. With this decision, the court denied Newport News' motion to dismiss. If you want to see the actual court document, you may click the star below. Moving on to the United States District 4th Circuit Court. Did the District Court misapply the statute of limitations? The 4th Circuit District Court ruled that the District Court correctly applied the statute of limitations. The judge explained that Newport News' failure to notify the parents of their rights is an alleged injury that is a clear violation of statutory mandates. Therefore, Newport News' claim that the District Court misapplied the statute of limitations was denied. Did the court err when it determined that the reimbursement for Stefan's participation in the LaVasse program was appropriate? The 4th Circuit District Court ruled that the District Court did not make any errors in determining the monetary award for Stefan's participation in the LaVasse program. Since the court agreed with the District Court's findings that Newport News failed to notify the Janes of their rights to a due process hearing, and thus failed to provide Stefan with a free public education, therefore Newport News' claim that the District Court erred on the monetary reimbursement was denied, as Newport News failed to follow through with proper procedures outlined under IDEA. Did Newport News waive its rights to challenge the reimbursement amount? The 4th Circuit District Court decided that since Newport News failed to challenge the monetary award of the District Court until after the summary judgment was entered against it, that it had effectively waived its rights. This was a tactical decision on their part to forego the opportunity to challenge the award. Therefore, they stopped themselves. If you want to see more from this document, feel free to click the star below. It will take you to a PDF file. If you want more information on the 2010 court case, feel free to click the link below. Keep in mind, Newport News went to court for a different reason, and they took the Commonwealth to court. If you want an update on Stefan Janes and the ABA program, Feel free to read the article by Lauren Tarkin published in the New York Times. Autism therapy is called effective but rare. Click on the link below. Here are my references and the honor code.